Good evening. Welcome to today's Vesta presentation on smart money moves post-divorce. My name is Renee Coleman, and I'm so glad you're here with us. At Vesta, our mission is to provide education, connection, and support to help you navigate the process with clarity and confidence. So this year, we celebrated our 13th year in the divorce business, and we had three founders that wanted a better experience. And for those going through divorce, they went through their own divorces and realized there's not a lot of sources out there. And so that's how Vesta came to be. So today's session, again, is focused on smart money moves post-divorce, a topic that can feel overwhelming, but one that's critical to ensuring your future stability and peace of mind. We have an experienced panel tonight of professionals who are going to share their insights for post-divorce, covering everything from financial health, legal aspects, real estate, your emotional state, mortgages. So keep in mind that the legal piece tonight is based on New Hampshire law. So this is a New Hampshire hub for Vesta. So the law piece is going to be geared for New Hampshire. We have other hubs across the country. I encourage you to check out the website, Vesta Divorce, and you can see other hubs in other states if you're looking for that legal piece. So I encourage you to stay engaged, take notes, ask questions, participate with the Q&A, and we will try to get to every question tonight. And with that, I would like to introduce our concierge, Mandy, and she can tell you a little bit about Vesta's concierge service.
Thank you so much, Renee. Hello, everybody, and welcome to tonight's presentation. We are delighted to have you with us. Of course, we're not delighted for your circumstances, but we are glad that you have found a way to educate yourself and empower yourself so you can make really smart decisions. You're going to hear a lot of information tonight. This panel is chocked full of vetted experts, so please get a piece of paper, a pencil, take some notes. And the good news is it's being recorded, so you can revisit the conversation so that you can really dial into what's going on for you. But honestly, the best way to do that is to have a concierge call, or even better, schedule a consultation with one of these amazing professionals. I have been with Vesta for 6.5 years, and it is really a privilege and an honor to be able to speak to people that are going through this major life transition and just be a tiny piece of the puzzle, tiny piece of your team, and try to help you discern who you need to speak with. It might be everyone here tonight on the panel, and it might just be a handful of folks, and we can figure that out together. Also, everyone that is here tonight will be getting our divorce interview guide, which is a really helpful tool. A lot of times we'll talk to people and they're like, I don't even know what to ask on my consultations. And we put this tool together to help cover that for you. You'll see that in your email tomorrow. I will put a link to my calendar in the chat. Please schedule a call and we will be following up with you tomorrow to see about your experience and how we can support you. I'm going to turn it back over to my colleagues. Thanks.
Thanks, Mandy. And so we're going to get started tonight. I'm going to pass it off to our first speaker on the attorney side, Kate.
Hi, everyone. My name's Kate Blake. I'm a family law attorney. I'm licensed in Massachusetts and New Hampshire, but you are in the New Hampshire Hub, so we will be focused on New Hampshire law. And I'm joined by Lori Barron. My practice encompasses out-of-court resolution, helping people through the mediation process, and also collaboratively trained. I do direct attorney negotiation, and then a component of my practice is also litigation, where we, for some reason or another, it's necessary to file in court. And then we have a court process to help people get divorced. I've been with Vesta almost as long as Mandy, perhaps. I do remember before COVID where we met in person with participants. And the great thing about Vesta is that you have all these vetted professionals. And I know that if you've spoken with Renee, you are qualified to get a mortgage. Renee is going to tell us what language needs to be in a final decree so we can make sure that you're able to comply with that final decree. Before I get started, since Lori and I are going to go back and forth on some of these topics, I'll let her introduce herself.
Hi, my name is Lori Barron. I'm also an attorney, family law attorney. I focus my practice, however, not on litigation, but on collaborative divorce and divorce mediation and also estate planning. I'm licensed in New Hampshire, Massachusetts, and Connecticut, serve clients in all three states. And I'll let Kate get started with the legal portion, and then I'll jump in regarding the mediation supplement or alternate option for the legal matter. Kate, go ahead.
So every state in the country has their own child support guidelines worksheet, and each state has a task force that puts together this guidelines, and those guidelines are usually updated every couple of years. So in New Hampshire, we have child support guidelines that you input a variety of information such as your income, your co-parent's income, information about health insurance cost, the how many children there are, as well as if there's any daycare expenses. And then the guidelines take all that information into consideration and they spit out a number, and it's a presumption that is the amount that is appropriate in your case. And that number is, if sometimes people will say, can I waive child support? Can I agree not to receive child support? I think it's very important to understand that child support is the right of a child. It is support for a child. So basic food, shelter, clothing, living expenses for a child. And it can be difficult if there is a difference of incomes to not have child support for a case. Sometimes if people have similar incomes and perhaps they have a shared parenting plan, then it may not be appropriate to have child support. But whether you, in any case, if there are children, a judge who ultimately has to approve your final agreement, needs to review the child support guidelines. And if you're doing something substantially different, then there needs to be a real explanation to that person, to why you're not doing that. Child support, because it is a guideline, is usually not negotiable. When I'm in court, judges are always asking, what do the guidelines say? What do the guidelines say? Child support, when you put your income into the form, it is taking your gross income into consideration as well as your co-parent's gross income. But when child support is paid, it's paid with after-tax dollars, meaning the person who receives it does not report it as income on their tax return. The person who pays it does not get to have any type of deduction on their income tax returns. Beyond that, there are other child-related expenses that need to be addressed in a parenting plan. Things like extracurricular activities, uninsured medical expenses. Children are considered emancipated at age 18 in New Hampshire, which means that a court cannot require either parent to contribute towards a child's college education expenses. But that is something that you and your co-parent can agree to do. You can agree to do something that is not covered by the law. So when you get divorced, there's usually a child support amount that is entered in that uniform support order. And then in the future, if there is some type of material change to somebody's income, if somebody gets a raise, if somebody becomes disabled and now they're unable to work, then child support can be modified in the future if there are reasons to do. And then every few years, you may also be entitled to have child support looked at again. It does require you to refile with the court to seek that modification. I think that was everything I wanted to cover on this slide. I don't know if you have anything that you want to add, Lori.
Sorry, I was on mute. No, just that for mediation, the topic of child support can definitely be negotiated. Again, you can't, waiving the support order is the rare exception, but in terms of the amounts based on a total assessment of all the assets, of all the factors, if there is room for negotiation, the mediation table is really a great place to do that. If there are issues that need to be addressed, to come to some sort of a child support agreement, it's the best place to have it, where it reduces the conflict because each party is heard and each party is able to express their concerns, their opinions, and ultimately come to some sort of an agreement before it reaches the judge's desk. Mediation can be helpful in addressing child support issues within the guidelines of the law.
So separate from child support is something called spousal support or alimony. That is support that is paid to a spouse for their reasonable needs. In New Hampshire, we have a statute that addresses alimony as being 23% the difference in gross incomes. And alimony is typically paid for half the length of a party's marriage. So those are the guidelines that we consider when we are negotiating a final agreement. What's important to understand is that if you do, and we call that what is periodic or monthly alimony that is paid, that is generally something that is modifiable and again can be changed upon a material change in circumstance in the future. So if somebody again has gets a raise, gets a different job with a different form of income, because usually these agreements will say that this is the dollar amount that is to be paid over time that may need to be adjusted if somebody's situation has changed. It is possible to have a non-modifiable alimony provision in your final documents. And what that basically means is that neither one of you could change that in the future. And usually, when we have a non modifiable agreement, that is by way of what we call a lump sum payment in lieu of alimony. So essentially, from one spouse's share of the marital estate, they may be paying the others, or basically prepaying the other spouse who is in need of alimony, a lump sum in order to have no further financial entanglement between each other. So that is something that in certain situations may make sense. And that may be why you bring somebody like Barb, a CDFA in, who can run a variety of scenarios and see if that is something that may make sense. The other piece that I think is important to understand, because I see this quite often, is when you're talking about that periodic or monthly alimony that is paid and is modifiable. I have seen many instances where people agree to alimony and maybe they're in their 50s when they're getting divorced. And now several years have gone by, and through no fault of the person who's paying, they are let go. And now they're in their early to mid 60s. They're not quite at that Social Security full retirement age. And age discrimination exists in employment world, and they have a very difficult time finding employment. They often can come into court and be relieved of their alimony obligation either by way of the monthly amount, by reducing the amount, modifying it down, or even potentially terminating. Judges do understand that type of thing happens. So I always caution the person who is receiving alimony that may not be the amount that you receive from now until the end date. It might end earlier, it might be reduced. So it's very important to not necessarily live your life as though you are always going to have those dollars. The other, I think, final piece that I want to mention about alimony is that, and I'm sure Lori will echo this, is that a judge is fairly limited in what they can do with respect to alimony. They usually just take that percentage, 23% of the difference. When you are in an out of court process or you're even just negotiating between yourselves, you can often have more creativity in alimony payments. I have a case right now where we are agreeing that the monthly alimony amount will be higher in exchange for a shorter duration of alimony payments. And that's not something that a judge could order, but it is certainly something that we could do in an out of court process. It's just nice to have other options that make sense for the parties. Do you have anything you want to add, Lori?
No, just to reiterate what I said before and what you just mentioned. The mediation table, the negotiation table is a great place to be creative and come up with solutions that the court would not necessarily be able to order on their own. If you want control over really what happens, and it seems kind of counterintuitive, but when the judge isn't making the order, you have more control. I just want everybody to kind of sit with that for a little bit, because it really is the truth. There's many ways to take from one area to put more in one area to make up for another area, or add more to one because the other is getting less. And in the end, it comes out to be fair and equitable, even though the individual things such as alimony or equity in the home may not be the full amount. Overall, it balances out, especially when there's conflict and deep kind of longstanding issues amongst the parties that makes communication and resolution difficult. When there's a lot of creative solutions where each party's concerns and issues are addressed, it opens the it opens it up for everybody to be comfortable with the agreement because they feel that they've been heard in the area that they're most concerned about. So, what
And
else
then
to add to that part?
before we pass it off to the next presenter, I just want to say that please make use of that Q&A function. Lori and I will be going off camera, but we're happy to answer any questions that you might want to pop in there, and we answer those anonymously so nobody else will see what those are. I think we're turning this over to Adrian now.
Hi, everyone. My name is Adrienne Beloin, and I'm a psychotherapist and a coach specializing in divorce and relational intelligence. I'm available virtually from anywhere, and I work with couples and singles to help them recover and thrive in relationships. And I will put my contact info in the chat so that you can have another way to clip something so that you can save it. So, what I wanted to talk to you about tonight is actually co parenting and financial abuse. You'll see that I have a statistic there, and this is the current census data where they track support payments. And what we're showing here is DV is for domestic violence. So, in a situation, if there has been any actual domestic violence, the rule to consider is that it's 99% true that financial abuse is occurring in the census tracking of how the actual payments are coming forward or if they're underpaid, things like that. With cases that are nonviolent, it's still 56.5% have issues where there's financial abuse occurring in the post-divorce relationship. So it's very common. And I have some advice that I can support you with today and let you know how I work with folks around avoiding some of these difficult issues that could come up later. So, no matter how amicable your divorce is, it is critical that you establish a new business like partnership with your co parent. And so I use the word, and it sounds funny to say that, but it's a little bit of a mantra that you want to use because you really want to appreciate that the relationship that you used to have with your co parent around your children, making decisions, paying for things, taking care of things for them in a certain way, it has to really change to feeling like a business-like partnership because of this concern around finances and for other reasons as well. And this means that there's clear expectations in place, there's responsibilities and clean lines. This will help you tremendously with moving on and building your new life. It will unburden you from the unnecessary enmeshment, conflict, and harassment that can occur. Your future partner will thank you if you have disentangled as much as possible from your previous relationship and the financial ties that exist between you. You can be every bit of a parent to your children. It's good to remember that without having the intrusion and dependency from dysfunctional past relationship. So that's something that I really help people feel encouraged around moving forward in a new way. So, the co parenting support that I provide for folks in this situation is I work with co parents in different ways to manage and cope with the conflicts that can arise in these areas. I work with people one on one. So, that may be you coming in, meeting with me. Your partner has, or your ex partner has, your co parent has no relationship with the co parenting support, but you yourself are getting one on one support on how to cope, how to navigate, how to prepare some of the strategies that you're going to put in place, and how to cope with the parenting aspects of it. So, one on one is an option, two on one. So, sometimes co parents are able to come in to a virtual session separately, but together, where we're all in the conversation together. And when they have any sort of disagreement or conflict in their relationship as co parents, and it's not going smoothly, it's a place where that can be kind of hashed out. And the other thing that I do is when there is a significant amount of conflict or contention or abuse in the relationship that's happening, and it's not productive to be meeting as a group, I meet one on one with each co parent separately, but in tandem sessions. And that can alleviate a lot of that strain that can happen when people are going back and forth with each other. So some of the advice that I have here is keep the agreement of what money needs to be exchanged in the legal decree. I help craft provisions to the parent plan to provide
clear boundaries and protocols as to why, when, and how money is exchanged. Ideally, this can be done ahead of the divorce so that it's in that final decree. However, modifications can be made even outside the court to add these guidelines if both parents can agree to them. It's meant to protect both parties, and ultimately, it's in the best interest of the kids that the parents avoid the conflict and have the resources provided for the children. Working with a neutral third party like myself in this work, co-parenting counselors can really settle parenting disagreements, can help minimize having to go to court, which is another form of financial abuse that can take place post-divorce. And I provide documentation of agreements reached, and this provides accountability and consultation on everyone's best interest as everyone's adjusting to the new thing. More advice is play by the book. So, what I often tell people is don't make any bro deals with your co parent. No bartering with your business partner, right? Like, you really need to settle into this idea that it can't be I'll scratch your back, you scratch my back anymore. It can get pretty messy. Everyone does this. Old habits die hard, and it's a huge mess. Think about the shared expenses really cleanly. Limit these items to the big things that really matter. It's not worth the back and forth with your business partner to split costs for school pictures or winter boots, things like that. Have a clear plan of who maintains what accounts and payments so that you have consistency and predictability. There's less to discuss and coordinate together. Some more parallel parenting tools that are really helpful is use court ordered and approved channels for exchanges. So, apps like My Family Wizard have business like features for making requests and paying right through the apps so that everything is timestamped, accounted for, and documented, including the agreements around the expense and the decision to make around the expense. So, should you need to go to court for any issues related to compliance, you have the court approved record. Think about having the judge require the payer pay the payee mandated support through the dedicated systems that exist so that things stay on the up and up around income changes, compliance, and enforcement. So, this would be like using the Bureau of Child Support Services rather than taking support payments directly from your co parent. So, those are the pieces of advice that I often work through with co parents, whether they're alone or they're together on some of these discussions. And it makes a huge difference. And it just really heads off a lot of conflict that can pop up later. Well, thanks. And I'm going to turn it over to Barb.
Good evening, everyone. My name is Barb Shigag. I am a CDFA, so I'm the financial side. I also have my CPA, so I'm a real numbers person. I work with clients through as a financial neutral. So I work with a couple that might be in mediation, helping them gather their financial documents together. And I also work directly with attorneys as an advocate for one particular person. So if you're feeling especially in the dark when it comes to finances, then those are the clients that I work with, and I advocate directly for them. And I also just even review settlements for a couple hours. If you just want to run the settlement by a financial analyst, a CDFA, that's great. I've built that into my practice because I really want to meet clients where they are. And some clients only need an hour or two of my time just to explain and make sure that they have all of everything written in and everything's being accounted for. So I think the key when you think about your post-divorce financial planning is it really starts before the settlement is final. Because the word final is that it's final. You don't have a chance to go back. So you really need to think about some of these items before everything is finalized. So what are some key considerations? One, your monthly income must be greater than expenses. There's no ifs, ands, or buts. And I always make sure that all my clients are in a position to not rely on the settlement that they gave them to chip away at that to cover monthly expenses. It's really important. And don't plan on, I think I'm going to get a higher paying job in the future. The market's going to do really well. Don't trust the variables. Rely on what you have. Make sure your monthly income covers all of your expenses. And even the courts recognize that as an important feature because no matter where you are, at least in New England, all the states require you to submit a budget to the court because even the courts care and they don't want you having to come back because this settlement agreement isn't working for you. So even the courts really will look to make sure that your income's greater than expenses. And as Adrian pointed out, something that I always make sure clients have very well documented is who's paying for what expenses. I think that's an important part. In New Hampshire, there is some assumption that if you're receiving full child support, then the receiving party pays for all of the children's expenses. But that was case law settled years ago, and that was before we had SAT tutors and SAT prep and driver's ed, club sports, all of those things you can't really rely on the parent who's receiving the child support to cover them 100%. And also make sure that you think about the future, especially if you have younger children. Some of these things you might not be incurring now, you will in the future. If you know your child's going to need tutoring, if you know they are on a track to play a club sport, things like that, it's really important that you anticipate this. And then it's important to review liquidity options. And I'm going to review a couple options that you have from retirement that you can get upfront liquidity out of some retirement options. And that's helpful if you're my typical clients have a lot of equity in the house and retirement assets. So it's important that there might be a solution to get liquidity for one party that might not be getting the house. And then again, Social Security is crucial, considering Social Security, and we'll review that. So I put up this slide really to talk about the phases about each phase when you're thinking about your budget. And really, your post-divorce budget needs to be really moved up to during. You really need to think long and hard about what your post-divorce budget will be. What will your mortgage payment be? What will your electric bill be if you're staying in the house and now having to cover it on your own? It's very expensive to run two households on the same salary. I can't stress enough how important you're looking at what your post-divorce budget be during settlement and making sure that this is something that's sustainable. And go to the next slide. And then as far as retirement assets, one of the things that I see also is pensions, which can be extremely valuable. And somehow, especially if people are younger, I just had a couple, he was working, had a federal job, which has a very lucrative pension. He pays into it a lot. And he's still fairly young, but he's worked there 20 years and will retire in 15. And he made it seem like, oh, it's just nothing and it should be thrown in. Don't discount pensions. They're extremely valuable, especially when one party will still be receiving Social Security. Social Security is not accounted for, but pensions are. So one party might only be getting a pension and not Social Security. So if you divide the pension in half, then what happens? This person's not only going to get half your pension, but they're also going to be able to get their Social Security. So it's important that you really evaluate and bring in a financial professional to help you evaluate the pension, because there's a lot of nuances to them. We could be here for an hour just talking about pension. So my main advice about pensions is don't discount them and always bring in an expert. Something else that I just want you to keep in your back pocket, there are ways that you can withdraw money from a 401k and a 403b. If you're receiving a transfer, let's say your spouse has a large 401k plan and you're receiving those funds, you do have a one-time opportunity to take money out of a 401k or a 403b without penalty. Again, it's one time and it's with a divorce. And so you won't have to pay that 10% penalty. You will have to pay taxes, but you don't have to pay that penalty. And more often than not, people do need a little bit of liquidity, pay their attorneys, maybe pay to move, things like that, and could use some cash. It really makes sense to think about. Again, it's something where if you do have a spouse and you will be receiving their 401k or 403b, bring in a professional to see how you might be able to get some liquidity out of it. Social Security. I can't stress the Social Security enough that why this needs to be taken into consideration at settlement. Social Security uses the highest 35 years. So if you've left the workforce, your highest years might have been 20 years ago. And then they always have 35 years. So if you have left the workforce and you haven't worked for 35 years, the years you don't work get replaced with a 0. So let's say you only have 20 years that you've worked. Those 20 years will get the credit, and you'll have 15 years with a 0. So long story short, your working spouse is going to receive a much more significant Social Security than the non-working spouse. And it's very hard to catch up. So even if you got divorced in your mid-50s and you're going to go back to work for 10 years or 12 years, you're still most likely not going to catch up to a spouse that's been working all along. Because don't forget, his or her Social Security is only going to go up and up as they make it. They take your highest 35, and yours is going to be you're replacing zeros, but most likely you're not starting at 55 where your working spouse is at 55. And so I always like to throw out this example because when I say you get half their Social Security, it makes it sound like it's being divided. So let's say Bob's entitled to receive $34,000 at 67. At age 70, he can receive $45,000. So Carol has been working, so she's entitled to receive $15,000 on her own. How much will she receive? She'll actually receive $17,166. And since that number is higher than what she would make. So Bob receives 34 and Carol receives 17. So she receives half of his, but he still receives all of his. So if you go to the next slide, something else to consider, when you collect Social Security, you actually get a choice. You can wait to age 70 and collect more. Now, collecting your spouse's benefit, there's no benefit to waiting. So if you're collecting a spousal benefit, do not wait until 70 thinking that you'll get a little bit more money. Start collecting when we're at full retirement age, whatever that age might be when you start collecting. It keeps going up and up. So it could be higher than 67. It's important to point out that if Bob waits until he turns 70, Carol will still get the $17,166 every year. Bob collects $45,000. So this is a fact that, so if they start with the exact same 401k balance, 50-50 division, when they're 67, it's really not apples to apples because Carol is going to have to be drawing down on that 401k a lot faster than Bob. So not only does he not get more money every year, he also has the luxury of more money that's going to grow tax deferred. If you have a long-term marriage and you have one spouse that is non-working, I can't stress enough to bring in a finance professional and look at this because you certainly want to try to equalize that Social Security payment in one way or another. Either it's through a larger division of assets or through an upfront payment or something, but it should be considered. And right now, more often than not, it's not considered. So now I'm going to turn it over to Robin, who takes over on the finance side once the divorce has been settled.
Good evening, everyone. Thank you so much. And thank you, Barb. Barb and I work a lot together in collaborating that pre and post divorce, helping you to secure your financial future. So I am a certified financial planner. I'm a managing partner of North Star Financial Planning, and we offer the wealth management services. So helping clients manage their money, specializing particularly in divorce. So how to help you take control of those assets and get ready to align them with your future goals. So the first thing that needs to happen when you step over that line legally is that you need to then step over that line, asset line, taking control of those assets. They're all listed in the divorce decree. So really going through that with a fine-tooth comb so that you know how long you have to begin the transfers, how much you're receiving, creating that list. I often do that list for my clients or with my clients so that we can sort and prioritize that list. So what needs to come first? What needs to come second? Generally, if you have joint accounts, you're going to want to close those out, but you need to open an account in your name and get those assets transferred over. Generally, you can work directly with a custodian on that, as long as they have a copy of the divorce decree. But generally, those things require both spouses to sign off. As Adrienne mentioned earlier in the program, that having a good relationship or having some relationship that you will have that spouse to help you get the assets in your name. There can often be delays and people dragging their feet on making those things happen. My recommendation is to stay focused, even though you may want to take a break from getting the decree signed. But if you stay focused and work with your attorney, work with your financial advisor to start this process, you will be far better off, as things can get missed and you could miss deadlines. So joint accounts, you need to get those moved. And divorce decree also lists any retirement assets. So Barb was talking about potentially accessing retirement accounts. We need to do that through a QDRO, which I'm going to outline that in a minute, but that is a legal document that will help you gain access to your retirement accounts if you need those to fund your lifestyle. And then seek professional help. So doing this on your own can be very overwhelming, especially if you've never managed the finances on your own. It can really sound like a different language. So find a financial advisor that you're comfortable with and utilize them to help you get through this process. So a QDRO is an ERISA. So it's an employer plan. So it's not an IRA. So 401k, a 403b, or a pension are the general ones that would be included. It's a legal document. So in the divorce decree, it may say that the parties have to pay for and find a QDRO specialist to draft for legal document. So you want to make sure that either through your attorney or on your own, if you contact the QDRO specialist to get that process started often. Again, where if you're working with a financial advisor, then you have to help you contact that person. And so you want to just make sure that there's deadlines to all of this. And so you just want to get on that as soon as possible. And then there's anything else I wanted to say about that. And then Barb mentioned being able to access these plans before you're 59 and a half. So it's not in the legal document that would happen, but once the assets at the employer stage. So the legal document is drafted, and then that document gets signed by you and your ex-spouse, and then that document needs to go to the employer plan. So whoever the employer is, for them to sign off and start the transfer process. And it's when the employer has the funds and are ready to transfer that you would put in a request for a one-time distribution, or perhaps work on another way to get it out. It's called 72T. I'm not going to go into it today, but I'm happy to answer any questions about that if someone's pre-age 59 happily access to those funds. So QDRO is a huge resource is what I want to say. You want to make sure you stay focused and start accessing those dollars.
So you want to change the beneficiary designations. So that would be any IRA and life insurance policy that you might have, annuity. If you're working, you might have employer plans that still have your ex-spouse. Different states treat this differently, but I wouldn't put that to chance. I would update their beneficiary designation as soon as possible. I mean, maybe children or whoever you want. You want to remove your ex-spouse from all of those. So those IRA accounts, in particular, again, on one of those assets that are moving in a divorce process. With an IRA asset, you can contact again the custodian directly to gain control of that asset if it's outlined in the decree. That may be 50% as an example of an IRA. You'd want to contact the custodian. Generally, they would make you put that asset, open an account at the custodian to then get your portion into your account. But again, it requires a signature from the ex-spouse if it's the ex-spouse's IRA. But it's when it's in your name that you're able to change the beneficiary. So again, working with a financial advisor to do that asset list. What accounts do you have? What accounts need to be retitled into your name directly or have beneficiary obligation attached to them? Special consideration regarding minor children are really, you don't want assets. So you don't want to move your children directly on a lot of these assets if they're under the age of 18, minor, or even in their early years of being an adult. So a trust or revocable trust is often used to be a receptacle for those assets. I mean, you would have the ability to manage those assets inside the trust, or the trustee would, whoever's named, that you would name a trustee who could help designate how those funds get paid out to the beneficiaries and revocable trust until they're of an age that you'd listed in the trust that it could get paid out to them. So it's a wonderful tool. Most of my clients with children have a revocable trust to help with that process. So the financial future. So this is where, let's assume that you've gained control of your financial resources and now you're trying to figure out, will be the asset last my lifetime? How much can I spend? How much can I share potentially with children? So establishing a spending plan, as Barb mentioned earlier, is key. You do not want to spend more than you have coming in. And you've done the work on your budget and cash flow pre-divorce. And so, life may change once you're on the other side of that, and you may have some different goals. So I think slowing down a little bit here and regaining your footing as to what's important to you, what are your financial goals, how your values changed, and how do you want to live your life, and trying to create a financial plan. We used that information in the context of a financial plan to help our clients determine if their money will last a lifetime based on these changing circumstances. So you want some sense of what we can spend that will sustain over your lifetime and still afford you a retirement that you would want to live. So establish a spending plan. How are you going to fund? So which income sources? Creating that payback. So you have maybe alimony, maybe child support, you have assets, you may be able to pull and sell some stock or use them investment income, you may be working, or you may need to pull from retirement plans, or you may be in retirement years, or if you're in your 60s and are in retirement. So maybe some of that will be coming with Social Security. So you need to understand where those income sources coming from, and then how are you going to be taxed on that? Is there a tax efficient way to structure those income payments so that you're reducing taxes as much as possible? Definitely want to work with the CPA, work with your financial advisor to build a tax strategy around your income stream. And then if you're in your working years, taking for retirement, maximizing your 401k, 403b, if you're able to, can only benefit you when you're on the other side. And then I think Barb mentioned monitoring your credit. You want to make sure there's no lingering accounts, that you're protecting your identity, that you do all the things that you can to secure your financial future. And then just recognizing that divorce is a huge life transition.
It's an emotions drive decision making, and it's normal to want to make quick decisions. It's normal to want to put this away and not deal with it. And my job within a financial advisor is to help clients avoid regret and want to secure their future. And so just understanding that might be a tendency, giving yourself time to pause and then pushing forward with all of this. It's Heather. Thank you so much. And now I'm going to pass you along to Laura Gamache.
Gonna come off mute. You guys say didn't see Laura with us.
I don't know what happened. She must have dropped off the call. My apologies. So Laura Gamache is our realtor in the group, and she was going to talk about the marital home and some of the things to keep in mind. And of course, before your divorce is settled, we need to figure out what's going to happen to the marital home and what are our options. Does one spouse want to keep the house? Are we going to sell the house? Excuse me. So we will skip over Laura's slides, if you will, Michelle. She may have lost connection. Maybe she'll pop back on. But we're going to move over to, I think, one more slide. Yes, thank you. Welcome again, everybody. I'm Renee Coleman. I am a residential mortgage lender. I'm also a certified divorce lending professional, so I work in divorce every day. I'm also the founder of Divorce Mortgage Planning of New England, and that's where we help our clients understand all of their options pre-divorce so that your divorce is structured in a way that we can actually execute what we're trying to accomplish. So when we're talking about mortgages and post-divorce, I think Barb mentioned it as well as Kate talked about. You may not have been the financial person in your household, and that's okay. Everybody takes on a different role in the household. But going forward, you will be the financial person of your new household. And so understanding your options and setting yourself up for future success is super important. Your settlement agreement is going to have lots and lots of dates in it that we'll have to follow. You will be required to act upon whatever is in the settlement agreement, and usually there are dates specific. Once your settlement is completed and signed off on, that's it. There's no going back. Kate and Lori talked about there are modifications, but generally not having to do with the marital home and dividing that asset once it's settled and there's no going back. And so we want to make sure that you're structuring your settlement from the beginning in a fashion, like I said, that is actually executable. If you're following the dates in the settlement, again, talking with the right people, so hopefully you spoke with a lender prior to your divorce being settled so that you know what your options are post-divorce. So things like the mortgage, the title, the deed to the home, and your homeowner's insurance. And I apologize, there is a typo in my slide there, insurance. But so all of those things need to be taken into consideration. So what's going to happen with the mortgage, specifically what's going to happen with the title and the deed, and your homeowner's insurance needs to be adjusted, right? So if you're selling the house, that's okay. Your homeowner's insurance will be canceled if you sell the house. But if one spouse is keeping the house, you need to make sure you're adjusting your homeowner's insurance, because there are, depending how your insurance policy is written, you want to make sure that the spouse remaining in the house is a named insured, and to make sure that you have the proper coverage. There was a case in Florida where the spouse that was awarded the house post-divorce went about their business, and the house actually had a major fire. And she put a claim in with the insurance company, and it turns out the named insured on her policy was her ex-spouse who no longer lived in the home. And the insurance company denied the claim. They did pursue it in court, and the homeowner lost, the insurance company won. So really important post-divorce and make sure that you have the proper homeowner's insurance coverage on your home if you are the spouse that's remaining in the home. So when we talk about keeping the home, so you have multiple options, right? Are you refinancing the mortgage? Are you assuming the mortgage? Were both spouses on the mortgage, and are there funds owed to your spouse? Barb talked about the division of assets, but all assets are not equal, and making sure you understand that equalization process. And so post-divorce, knowing and understanding that it's now settled, and again, hopefully you've spoken with a lender beforehand, but now comes the time where you have to execute on whatever terms were determined in the final settlement agreement. If you're refinancing the home, are you receiving support as income to qualify for that mortgage? Have you met all of the qualifications to do that? And how does your credit look? We know during this process, people get busy, you have a lot on your plate, but a lot of times we can miss a payment on something. And this is where it's going to be critical to make sure that you're paying things on time so that when it does come time post-divorce, if there's any mortgages that need to be refinanced, or maybe you're selling the house, and whether you're going to be purchasing another house or renting, either way, both will require a good credit score. Just being mindful of your credit post-divorce. And I think even Robin mentioned that as well, watching your credit post-divorce and just making sure that things are being paid. So if you're keeping the house, those dates are going to be critical in the settlement to understand the time frame that you might have in order to refinance or do an assumption. So again, hopefully you spoke with a lender prior to, and preferably a CDLP who understands the divorce world, so that your final settlement gives you enough time to accomplish either of those scenarios. So if you're for the support piece, it will be important a lot of times if support is starting post-divorce, it will be important to understand where those funds need to be received. Again, this is if you're using support to qualify for a mortgage. Where those funds are being received is going to be very important. What account and whose name is on that account, how long the support's going to last. So again, make sure you're talking with a lender pre-settlement so that the agreement can be written up properly. So for your credit, again, we can help you understand. We want to know before the settlement anyways, what debts are in your name, and are any of those marital debts, and are they being split? So from a lender's perspective, when you come to us for a mortgage and we pull your credit, we're going to see any accounts that are in your name, of course, will show up on your credit report. We have to debt you for all of those. So it doesn't matter, however the divorce settlement is written up, if it's on your credit report, I have to debt you unless the divorce settlement specifically states a particular debt is no longer your responsibility. So if that debt has been shifted to your spouse and your spouse is now responsible for those payments, then we can exclude that from your ratios. Your debt to income ratios is what we're looking at to qualify you for a mortgage. Again, make sure you're talking with a lender up front. We understand credit. And then if you need some help with your credit, maybe your credit's taken a hit and there's a few dings in it, that's okay. We can help you with that too. So we have access to simulators, what-if simulators. If we remove this, if we fix this, if we pay this down to a certain amount, it can help us with your scores. The better your score, the more mortgage programs available to you, and also the better interest rate for you. So again, credit is super, super important. And I already talked about the homeowner's insurance and making sure that you're removing the departed spouse and making sure that you are on the policy. Next slide, please, Michelle. Thank you. Now, if you're not keeping the marital home, are you receiving a buyout? Much if you were the spouse keeping the home, you may owe your spouse a sum of money. If you are the spouse leaving the home, that could be that you're selling it, but also it could be that you're receiving the buyout. What do you plan to do with that money? Where do you plan to put it? In some cases, we're very fortunate in New England. We have a lot of equity in our houses. A buyout could be a significant amount of money. So, where are you going to put that money? And will you be purchasing a new home? There will be some rules around where that money is kept and when it can be used to purchase a home. So keep that in mind. Let's see what else. If you are the spouse departing, we see this a lot. If you're the spouse leaving the home, but you're on the title, likely your settlement agreement is going to have some stipulations in it that will require you to cooperate with your spouse. If your spouse is keeping the home and perhaps refinancing to take you off of the mortgage, or you also will want to come off the title, you will need to cooperate with your ex-spouse to facilitate that. Again, depending how your settlement is written up. So just keep in mind that even though the divorce is settled, there's still going to be a few things left that you will have to work with your ex-spouse to finish up. And then lastly, if you're planning to own the marital home jointly, so meaning we see this a lot when there are kids, maybe kids in high school, and we're going to jointly own the home for 2 more years till the kids are done high school, and then we'll sell the house. So you're owning the house together, which is okay, but there are some things that you'll want to think about. Again, homeowners insurance, you really want to address that. Who is the spouse living in the home to make sure that the home has the proper coverage? And then title issues. How is the title held? So in New Hampshire, typically the title is held in some sort of tenants in common, maybe with some rights of survivorship. So you want to make sure that this is addressed, because if you both own that home and something happens to one of you, and how is the home going to be split? If it's not spelled out, there could be some issues with your portion of the home going into probate and being passed on to your heirs. And now this remaining spouse may have some issues if they're trying to sell the house. So again, title issues certainly come into play post-divorce if you're owning the home jointly. And a few other things you'll want to make very clear in your settlement agreement if you are going to jointly own for a time. Make sure it's spelled out who's going to be paying the mortgage, who's responsible for any repairs or maintenance, who gets to claim property taxes and the mortgage interest on their federal tax returns every year. When you sell the house, how are the proceeds being split? If you escrow your taxes and insurance, what happens to the remaining funds in the escrow account when you do sell the home? So these are all things that you want to make sure are addressed in the final settlement agreement so that post-divorce, again, we can execute so that you're not in contempt. Even though you have a legal document that's requiring you to do these things, just because it's a legal option doesn't necessarily mean it's a lending option. So we want to make sure that the two coincide. So to avoid any issues post-divorce, I recommend talking with a CDLP beforehand so we can help you structure that settlement agreement. So I'm going to put my contact information in the chat. I do offer free consultations. If you have any questions, I will post that. And I did not see
Laura did not
get. Oh, we did get Laura back. Excellent. I will pass it on to Laura then.
Thank you, Renee. My apologies, everybody. I had a little bit of a technical issue just before, of course, it's my slides up. So I'm going to keep my camera off just so in case my internet was being a little funny. So hi, everyone. Good evening. My name is Laura Gamache. I'm a real estate broker. I am licensed in New Hampshire and Massachusetts. I have referral partners that I can assist you with. So if you are not local in New England, Still, please reach out. I have partners that work all over the country and all over the world, to be honest. So, wherever you are, if there's real estate involved, I can certainly assist. So, like many have already spoken upon, is regards to if someone's keeping this house, are you going to be selling it as part of the divorce? So, like Barb mentioned, when you hit the post divorce, this is final. Keep in mind that we need to be, myself needs to be brought on much earlier in the process, if not immediately, if there is any real estate involved, whether it's your primary residence, whether you have a business and you own a commercial property or you have investment properties, et cetera. So the earlier that myself or any real estate broker is involved, the better, because at the end of the day, they're going to need to have that dollar amount because the attorneys are going to turn to me and say, okay, I need a dollar amount at the values of these properties. So you know how to go about, of course, with your negotiations with your to be ex-spouse and make sure that you are receiving your fair share of those assets. A lot of the times, if it is going to be something that the property will be sold post divorce, I'm there helping throughout the transaction or throughout that process. It can be a short term. I've had ones that have gone on for many years, but they've needed just to have some updated market analysis or pricing as they have maneuvered throughout that process. If you're trying to sell it before the divorce, then many things that we're kind of keeping consideration is where are you going to be going next. So depending on what market you're in and how it is trending is also very important as well, because sometimes if we need to make some contingencies, I'm sure that if you're purchasing next, we have necessary to stay and set up in advance to make sure that you are kind of set on the path. First and foremost, not being just have you situated what you need to go, sitting or renting, which might be something as well. I mentioned market analysis versus an appraisal. So there is a difference, right? Market analysis, any real estate agent can provide that, typically without any type of fee. An appraisal, therefore, is a licensed appraiser that would charge a pretty significant value of coming out and giving an actual appraisal for that particular property. Typically, it can be anywhere from $700 upwards for an appraisal, depending on where you are in the kind of divorce process and negotiations. Myself can provide a market analysis very quickly and easy for again, yourselves or the attorneys. So they have that right off the bat. So just knowing some costs involved right off the bat, knowing from going into there. If we are going to the process of selling the property, a lot of times I'm working with both parties, depending on who is living where. Obviously, both parties are typically having some type of ownership, and it's part of the divorce decree that the house will be sold. So it's been a pretty tough time, contentious between the parties, and sometimes we need to have some conversations about the condition of the property and or some deferred maintenance that might have occurred to the property since there has been a little bit of a focus on elsewhere outside of the actual property. So a lot of times I'll be working with both parties, and if monies need to be spent on preparing the house and or getting fixed up, and making sure you keep track of all of those expenses so who has spent what to get the house ready for the market and or fixed what. So selling the house, of course, it's the listing process. That's where we start. We start walking through the house and what we need to do and what's a priority in the sale. Everybody's different. Yes, of course, every seller always wants top dollar, but sometimes it's the timing of what type of market we're in and where we need to make sure we get those dates done and met by. The showing process and access, who's living in the home. So who is this going to be coordinating with? Do we have kids involved that we need to coordinate having them out of the house for showings, open houses, etc. And again, what's your typical absorption rate for your area? How long is it taking for houses to sell in your area? So that's what we will be providing that. Possession, of course, attorney communications, all of that. We are, of course, keeping everybody in the loop. And I am typically the mediator between. I'm telling both parties of what's going on in the process of this. And I am, again, discussing that with the both spouses that are on there. They're typically not discussing it amongst themselves. I am the one that is, of course, keeping them up to date on everything as we are going through that process. So again, many things can definitely be going in the process of that sale. But again, that's what we're here for, to kind of help keep it as smooth as possible when it kind of comes to the selling of the property. So I think at this point we're passing along. I think Michelle, are you up next?
Yeah.
Okay.
All right, everybody. I like to go last because that was a lot of information. I'm a certified divorce coach, so I can help you bring all of this together at any point of the divorce process. But since we're talking about post-divorce, you learned a lot about post-divorce. You now have an agreement. Now, what do you do? So we can take a look at it, whether I was with you when you created it, agreed with it, signed it, or we start working together after. One of the biggest things, the questions that is after is the QDRO, that qualified domestic relations order. As a previously divorced person, I personally did my own QDRO, so I'm very familiar with QDROs and have referrals to provide people to get the QDRO done and help assist you through that process. The entire process of divorce is not only emotional, but it's very overwhelming. And having a coach walking side by side with you that you can even just touch base with for 15 minutes here and there, ask questions, get more information, think things through. Maybe you were talking with Bar when she was giving you some information and you want to just think that through with someone. I can be your thinking partner. That's what coaches help you with. So coaches don't just focus on the emotional aspect. We're here to help you navigate every aspect of divorce, including post-divorce. Okay, now we've got to sell the house. What do we need to do? All the other things, doing the credit checks, getting your name off of things, onto things. You still need the support to navigate post-divorce. And that's what a coach can do for you. There's all different kinds of coaches, as you heard Adrienne mention earlier. Adrienne and I focus a little bit different on different aspects of divorce and parenting. But that's it in a nutshell. I know you've gotten a whole lot of information. Thank you all for sticking to the end. And I'm going to put my email in there, but the concierge is going to be reaching out to you tomorrow. So you will also be able to get my information there if you don't get it because you've hopped off already. Were there any other open questions that we have? Any last minute questions anyone wants to put in the Q&A?
I don't see any in there right now, but we do have a few more minutes if anybody wants to add a question for one of the panelists to
I did
answer.
want to address one of the questions that was asked before the webinar, and it was regarding filing with if you should, even though you're going through a divorce, if you should file married or each file married separately. Unfortunately, the only winner, if you guys each file married separately, is the government. You'll each be paying more. So I would highly recommend, even though it may be contentious, to see if you can work out a deal with your soon-to-be ex-spouse. And especially, most likely, if you are more of the lower wage earner, you may benefit from filing married separately, and you may get, let's say, $1,000. But if you file married joint, then maybe your spouse, instead of having to pay $10,000, might only have to pay $5,000. So if there's some way that you can leverage that savings, I would encourage you to see about, don't just blanket give into it, because you could leave money on the table. But maybe the deal is if you were supposed to get money back, maybe your spouse pays you that money. And in the meantime, they're saving more than that. You also then get immediate access to all your spouse's information from a tax perspective, and you're not dragging your heels and having to petition for this to be disclosed. So that's another benefit. And chances are you've already made the decision since we're after April 15th, but for all of you going forward, if you're not quite divorced on 12/31, it's really something to consider.
Yeah. Great information. Thanks, Barb. All right. I don't see any other questions in the Q&A. So we will let you go for the night. Thank you, everybody, for joining us. And I hope to see you again. Michelle said our concierge will be reaching out to you tomorrow and in the next few days. If you would like to connect with any of the panelists tonight, she can help you with that. Otherwise, have a great night, everybody, and thanks for joining.
Thank you. Bye, everyone.